This entire process takes 30 days. And so what normally occurs is when the consumer sends the letter to the credit reporting agencies will scan and reduce that letter to a two-digit code. They will then the furnisher will get a copy of that letter as a scan, and the copy of any dispute letter, any documentary evidence that's attached. The furnisher is supposed to conduct an investigation uh, in their own systems and then report its results to the CRA. The CRA is the credit reporting agency is supposed to conduct its own investigation. It's supposed to verify the information independently, whether that means requesting documentation from the furnisher. They have to review the documentation that the consumer has provided and make a determination of whether the account needs to be updated, suppressed, or deleted. And in the context, and again, we're talking about it in the context of debt settlement. And so, really, what I'll do is I'll give you guys a brief understanding on which contexts this occurs in the debt settlement context, in the debt settlement arena. Number one, the consumer paid the account in full. Of course, this is the original. This is like the typical pattern that occurs. I mean, not necessarily in debt settlement, but in general, where the consumer pays the account in full, but the credit report shows that the consumer owes a balance. Obviously, if a consumer pays the account in full, there should be a zero balance. And in this case, the consumer will likely have access to their payment logs, and they can attach on that payment proof that's going to be sent to the credit reporting agencies and the furnishers that the consumer was in fact not late, or and should not be a balance because the account has been paid in full. Um, this isn't always in the context of that an account is late. This is more in the context that the account has been paid off completely in full, and therefore there should be a zero balance.